and welcome back to Passing the Baton. I'm Jared Haidt from Tracktown Law, and today we are discussing intestacy, the state-written estate plan you never knew you had and probably don't want. A quick disclaimer. I'm a lawyer, but listening to this podcast does not make me your lawyer. This does not create an attorney-client relationship. For advice relative to your specific needs, please contact a licensed attorney in your state. Dying intestate means you left no valid will. In Oregon, the legislature steps in with a rigid family tree. If you die married with no children from another relationship, your spouse inherits everything. Sounds simple, right? Let's add complexity. A second marriage, stepchildren, estranged siblings, and the statute can produce shockingly unfair results. Consider Mark, a widower with 2 adult daughters who remarries Lisa late in life. Mark never updates his will. He dies intestate because the old will was revoked by marriage under Oregon law. The statute now gives Lisa half the estate and each daughter 1/4. Lisa gets controlling interest in the family cabin, even though she never set foot there. The daughters must negotiate or file a partition lawsuit to keep their childhood retreat. Intestacy ignores unmarried partners completely. Oregon doesn't recognize common law marriage. Your partner could be evicted from the share home by your next of kin. Stepchildren you've raised since kindergarten inherit nothing. Close friends who supported you through illness? 0. Intestacy also complicates administration. Any heir can petition the court to become personal representative. The race to the courthouse often crowns the least prepared relative. Bond requirements kick in, costing hundreds. Creditors and distant cousins receive formal notice, and the estate remains open long enough to be certain no one else has a claim. I've seen modest estates linger 18 months because a creditor filed on day 119 of the 4-month window. Guardianship for minor children is another landmine. A will lets you nominate guardians. Without it, multiple relatives may petition, sparking costly custody battles. Judges decide based on testimony, home studies, and sometimes the child's preference. The process can drain savings set aside for college. Intestacy even affects taxes. Oregon's $1 million estate tax threshold doesn't care how assets are titled. A poorly planned estate can incur tax that smart lifetime gifting or trusts would have avoided. When heirs argue, they rarely coordinate tax elections, leaving money on the table. How do you avoid intestacy? Sign a valid will. Both Oregon and Idaho require 2 disinterested witnesses in your conscious presence. No notary is required. But please, use a lawyer. One-size-fits-all software platforms are not in your best interest. Store the original signed document in a fire-safe file and tell your executor where it lives. Oregon law revokes gifts to ex-spouses automatically, but other states differ. Moving across state lines without revisiting documents can resurrect old beneficiaries. For unmarried partners, consider a domestic partnership agreement, joint tenancy, and beneficiary designations to guarantee inheritance. For blended families, trusts can balance care for a surviving spouse with eventual gifts to children. For tailored advice on keeping your estate out of the intestacy maze in Oregon or Idaho, visit tracktownlaw.com and send me a note. Next episode explains why every Oregonian over 18 should have a will.